In this lesson, what we're going to do is look at the historical development of international human rights law. Now, for the most part, we are going to be limiting the scope of our inquiries to that of the the post Second World War within the 20th century. And the reason for this is because not necessarily the fact that we can't go back further, because there are definitely elements of, and at least sprinkles of, the idea of human rights law that dates much further back than the end of the Second World War, but just that the major instruments of international human rights law that we expect to see and that we do see within, for example, the Universal Declaration, for example, the development of ICL, the development of the United Nations Charter, all takes place after the Second World War. So we're going to sort of cover the build-up to the Second World War, some of the developments within the Second World War, and then post-Second World War, essentially. And like I've said here, this is not to suggest that there is not a tradition of international human rights that's existed from an ancient perspective, never mind at least from the Enlightenment period, although the Enlightenment, of course, was a major turning point for a number of different ideas relating to legal and cultural developments. We are going to be limiting ourselves to the 20th century for the most part. So let's think about the development of international human rights post World War II, or at least during and then after the Second World War. So we can see that some of the earliest 20th century mentions of the idea that individual people have fundamental human rights dates to the year of 1929 with the International Declaration of the Rights of Man. Now, this was issued by the Institute of International Law. We have this sort of quite interesting nebulous period between the world wars with the League of Nations and the development of a number of different principles of international law there. Now, references by more prominent figures began to take place during the Second World War itself. There was this growing idea that the Second World War really ought to be an impetus for a major shift in the ways in which we regulate and govern individuals across the world from an international law perspective, and that human rights should play a very key and central role within this particular framework. So, for example, President Roosevelt sent a message in January of 1941 to his legislature, to Congress, where he proclaimed the existence of the four fundamental freedoms, as he described them as the four essential human freedoms. Now, according to Roosevelt, these human freedoms were the freedom of speech and expression, the freedom of every person to worship God. We can sort of shift the language ever so slightly to that of the freedom of religion in some kind of way in the sort of modern language, the freedom from want, and then the freedom from fear, which are of course a little bit more broad and a little bit less defined, but we will get to some of these and what some of these may have meant in the future lessons time, so don't worry. Now, continuing on then, we're talking about during the Second World War at the moment, and we have, at the same time, during the Second World War, in fact, the same year, I believe, the Atlantic Declaration. So this was made in August of 1941, so a few months after that particular issuance to Congress. And it was a declaration between two of the Allied powers, between President Roosevelt and Prime Minister Winston Churchill. And what it essentially did was it made a number of different declarations, it made a number of different claims, but within the declaration, they sought for the quote, sought for the men in all lands may live out their lives in freedom of fear and want. So we have again reference to the two essential freedoms that were listed by Roosevelt in the earlier issuance to Congress. But we have as well this idea that all men of all lands may live out their lives in freedom of fear and want. So this gives a certain amount of universality to the concept of human rights. And this is one of the key principles of human rights when we look at it from a philosophical perspective at least, which is this idea that human rights are rights that are endowed to every single human being on Earth, regardless of any of their particular characteristics, regardless of where they are in the world, regardless of their age, their gender, their race, etc., etc., etc. This sort of universality is enshrined from and founded from a philosophical perspective in some of the early Kantian perspectives of cosmopolitanism. And so this idea of a cosmopolitan principle is this idea that we are all citizens of the earth rather than being aligned and associated with individual states. Now, from that perspective, cosmopolitans have extended that idea to something of a moral duty to take care of others and to be able to have some kind of moral duties towards people outside the confines of the state. Now, that's a wholly different philosophical question and a wholly different philosophical debate. But what is interesting in the Atlantic Declaration is it is essentially enshrining this idea that individuals, regardless of any of their particular characteristics, the only characteristic that is important and the only characteristic that matters is the characteristic of being a human. Hence why we get this idea of human rights from this principle. Now, what's important and what's interesting is the interaction that is had, at least at the end of the Second World War, between the development and growing of a human rights doctrine within international law and a growing doctrine of international criminal law. Now, for those who study international law will know already that there is this intersection that exists. It's almost a three-way intersection between the international law as it pertains to human rights, international law relating to the regulation of armed conflicts, which is international humanitarian law, and also international criminal law. They tend to overlap in certain key ways. And international criminal law is very, very similar in the sense that it regulates a number of different things, but what's important is that some of the crimes that are cited in international criminal law, at least especially during the end of the Second World War, are crimes that seem to recognize the existence of this concept of humanity and this concept of a human existence from which every single person who lives on Earth has a certain amount of stake in that particular process. And obviously I'm talking about the crime of crimes against humanity. So when we see this, we see that this is an important step. And of course, at the end of the Second World War, for the most high profile of these developments in international criminal law is, of course, the Nuremberg trials, the trials of the Nuremberg International Military Tribunal as codified by the London Charter. Now, one of the crimes which is important for us within the Charter, as I've mentioned, is this concept of a crime against humanity. There were two other crimes that were specifically cited, which were crimes against peace and also war crimes, which were sort of formed as part of the auspices of international humanitarian law. So crimes against humanity is interesting for our understanding of human rights because essentially the concept of a crime against humanity provided that there was the existence of individual criminal responsibility for certain acts which were deemed to constitute the actus reus of an offence against humanity. The idea that we are acting in a way that, first of all, recognizes this collective principle, this collective identity, which is that of humanity, and that a crime against humanity, therefore, is a crime against this particular identity. So let's think about this from the context of further developments within the post-war history, and the first of these is, of course, the development and the creation of the UN Charter, the Charter for the United Nations. It was established as the main legal instrument for the United Nations, and the United Nations Charter is a significant step in the development of international human rights provisions, while not necessarily citing specific human rights which states are duty-bound and obliged to actually uphold. It is still nonetheless important because the preamble to the UN Charter makes clear that people of the United Nations were determined to save succeeding generations from the scourge of war. In twice our lifetime has brought untold sorrow to mankind, obviously making reference to World War I and World War II. And to reaffirm faith in fundamental human rights, in the dignity and worth of the human person, in the equal rights of men and women, and the nations large and small. This is probably the first major citation of a specific doctrine that is upheld by the states who are signed on to and are members of the UN Charter, i.e. signatories to the UN, of this idea of human rights. We have here a specific reference, i.e. to reaffirm faith in, quote, fundamental human rights, in dignity and worth of all human persons, equal rights of men and women. Now, the UN Charter makes it very clear that a central concern for the United Nations as a general basis is the protection of fundamental human rights. And so while this is undoubtedly within the UN Charter a step in the right direction, as I mentioned earlier, it doesn't specifically cite specific rights in the sense that there is not the UN Charter telling us that we have a right to life or freedom of expression, for example. And nor does it specifically implement certain international obligations on the part of member states. Now, the UN Charter does that in other areas of international law, but the obligations on the part of member states in relation to human rights is not done with the UN Charter. But it is still quite interesting that this idea of citing specific rights on the one hand and imposing specific obligations on the other was an idea that was had in the minds of those drafting the UN Charter as early as the San Francisco Conference. And as early as the San Francisco Conference, President Truman, President of the United States at the time, was making reference to the concept that there needed to be an international Bill of Rights, in a similar sense that there is a Bill of Rights within the US Constitution, the Bill of Rights being the first 10 amendments to the US Constitution. Truman was making reference to this idea of an international Bill of Rights, a Bill of Rights that would apply to all members of the planet, or all members of the United Nations. This concept of an international Bill of Rights, therefore, is extended into and is then worked upon by and eventually comes out to be the Universal Declaration of Human Rights, which we will look at in the next lesson.